Whenever you're ready.
Sorry, Judge.
That's okay. You said you are ready?
I'm ready.
Okay. All right, Ms. Rivers, are you ready to hit the record?
Yes, Judge, I'm ready.
Great. This is position 9 from this morning's calendar, State versus Willie Jones. Mr. Jones is at the podium with his lawyer, Ms. Rios. Ms. Davis is here for the state. It's indictment 25 SC 001 607, several counts of burglary in the second degree. Mr. Jones, in a moment, Ms. Davis will put you under oath, ask you some questions. You've heard those questions several times this morning. It's your turn to answer them. If you've got any questions of your own, will you let me know?
Yes, sir.
Okay, Ms. Davis?
Please raise your right hand. Do you swear or affirm that the testimony you will give in the matter before this court will be the whole truth and nothing but the truth?
Yes, ma'am.
Okay. Please state your true, correct, and legal name for the record.
Willie Frank Jones.
Are you at this time under the influence of any alcohol, drugs, or medication?
No, ma'am.
Is there any medication that you normally take that you have not taken today?
No, ma'am.
How old are you and how far have you gone in school?
40, high school.
And what high school did you attend?
George Washington Carver High School.
Did you graduate from high school?
Yes, sir.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
Do you understand that you're charged with the following offenses? Burglary in the second degree. There are 3 counts.
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your lawyer, Attorney Rios, about all the facts and circumstances known to you regarding this indictment, including any potential defenses?
Yes, ma'am.
Do you need more time to discuss this case with your attorney?
No, ma'am.
Are you satisfied with her services?
Yes.
Attorney Rios, do you waive formal reading of this indictment and any and all defects therein for the purposes of this plea?
Yes.
Mr. Jones, do you remember having been arrested on these charges?
Yes, ma'am.
Your Honor, the state is unaware of any outstanding warrants related to these charges. Attorney Rios, are you aware of any outstanding warrants?
No.
Mr. Jones, has your attorney advised you of the minimum and maximum sentence for each charge to which you're pleaded to today?
Yes, ma'am.
Burglary in the second degree is a minimum of 1 year and a maximum of 5 years.
Yes, ma'am.
Do you understand that today you're entering a negotiated plea of guilty, which means the state will recommend a sentence to the court?
Yes.
Do you understand that the court is not required to accept the state's recommended sentence?
Yes.
Do you understand the court has the right to sentence you to the maximum possible sentence on each charge?
Yes.
Do you understand that there are multiple charges to which you're pleading guilty today, and the court has a right to run those sentences consecutively or one after the other?
Yes.
Do you understand that if the court decides to order a sentence that differs from our negotiated plea, that you have the right to withdraw that plea?
Yes.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as other jurisdictions, including federal courts?
Yes.
Do you understand that if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at a trial would, and that is true regardless of any advice by your attorney or anyone else? Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm or use a firearm in a crime, you'll be guilty of a felony, which may carry a sentence from 1 to 15 years in prison?
Yes, ma'am.
You understand there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following trial.
Yes.
For example, your guilty plea may affect the right to vote, to hold public office, to serve on a jury, to obtain a passport, to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
You understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial. Do you understand that you may have only a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that you have only 4 years from today for the felony charges to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
How do you plead to the charges in indictment 25 SC 001607 to burglary in the second degree?
Guilty.
Has anyone forced you, threatened you, or promised you anything to get you to enter this guilty plea?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes.
Is this guilty plea freely and voluntarily given with the full knowledge of the charges against you?
Yes, ma'am.
Your Honor, the state believes at trial the evidence would show between the dates of July 3rd through July 5th, 2023, located at 173 Boulevard Street in Atlanta, Georgia, in Fulton County, that officers with CSX Railroad were alerted to a theft of some of their cars that were in the yard. There appeared to be damage to shipping containers. Their locks had been removed. Tires from inside of those shipping containers were stolen. There were microwaves that were also stolen as well. There is some surveillance footage and photographs of the individuals who were involved in this theft. At the time of July 5th, Mr. Jones, along with one of the other co-defendants in this case, was arrested on scene after they were alerted to a theft occurring on CSX property. We are extending the same offer that we did with the other co-defendants for this case, and we are recommending a probated sentence for Mr. Jones. That would be 5 years probation. Restitution, we will reserve that right, and we're still waiting on some documentation from CSX. An anti-theft course, 60 hours community service. He would need to complete his GED if he was a graduate, but I believe Mr. Jones already indicated he is a graduate, and to stay away from all railroad yards for the duration of his probated sentence.
Got it. All right. I follow all that. Thank you. Good afternoon, Ms. Jackson. Do you have any criminal history information on file for Mr. Jones?
Yes, Your Honor, there are 12 cycles. The last arrest was July the 18th, 2025 in Henry County, Georgia, for driving while license suspended or revoked. There was no disposition for that arrest. Does appear to have an open case pending in Clayton County for driving while license suspended or revoked. And he appears to have an additional open case pending in Douglas County for cruelty to children in the 3rd degree. Nothing in addition, Your Honor.
All right. Ms. Rios, I didn't hear anything about convictions. Is this a first offender plea? Even though there are these other things in the works, not that any of these driving with license suspended will be felonies. I don't know about cruelty in the 3rd degree.
Misdemeanor too.
I think so too. Okay. So Mr. Jones is interested in first offender.
Yes, sir.
All right. What else do you want to tell me about him and this situation?
He is 40 years old. He currently works for AJ Towing. He's been there for 8 months. Prior to that, he was working at a body shop doing, working on cars. He has a 10-year-old. Oh, no, I'm sorry. He was doing that. I'm sorry. He has a 20-year-old and a 2-year-old. I'm also asking for a behavioral incentive day of 2 years, given that he's 40 years old and has never had a felony conviction before. I don't think this is going to be a continuous thing. And hopefully if he doesn't have any issues over those 2 years, he can be off probation.
Okay. Anything else? All right. Mr. Jones, you're working at a towing company now?
Yes, sir.
Is it your towing company or someone else's?
Someone else.
What do you do?
Just tow cars.
Okay. And what's the radius? Are you,
Flatbed operator.
oh, it's a flatbed.
Yes, sir.
Okay. And what's the radius? Are you just in Fulton County, you all over Georgia?
Just about all over Georgia.
Okay.
All right, let's talk about that. We had Mr. Willie Frank Jones at the podium for a guilty plea to 3 counts of burglary in the 2nd degree, and what unfolded was a quiet but layered courtroom moment. Judge McBurney opened with his usual calm and direct approach, confirming Mr. Jones was ready, clear-headed, and understood what was about to happen. The plea colloquy, led by Ms. Davis for the state, was smooth and thorough, with Mr. Jones answering each question respectfully and clearly. No hesitation, no drama, just a 40-year-old man taking responsibility in a courtroom where everyone seemed to be rooting for this to be a turning point. Mr. Jones was linked to a theft that occurred over the 4th of July weekend in 2023 at a CSX Railroad yard in Atlanta. According to the state's presentation, shipping containers had been broken into, and items like tires and microwaves were taken. Mr. Jones was reportedly caught on the property alongside a co-defendant, with surveillance footage supporting the case. But despite the charges, the state offered a 5-year probated sentence consistent with deals extended to other co-defendants. The terms included 60 hours of community service, completion of an anti-theft course, and a condition to stay away from all railroad yards during his probation. Restitution is still on the table, pending further documentation from CSX. Ms. Rios, representing Mr. Jones, handled the defense with clarity and care. She confirmed that Mr. Jones wished to take the plea under Georgia's First Offender Act, which the court accepted, noting that he had no prior felony convictions, despite having a record that included 12 prior arrest cycles. Judge McBurney carefully reviewed that background, some open cases for driving on a suspended license, and one pending for cruelty to children in the 3rd degree, but no prior felonies. That opened the door for a first offender resolution, giving Mr. Jones a shot at having the conviction wiped from his record if he complies with probation. The courtroom tone stayed measured and constructive. Mr. Jones shared that he currently works for AJ Towing as a flatbed operator covering jobs across Georgia. He's also a father of 2, a 20-year-old and a 2-year-old, and it was clear that his defense counsel saw this case as a moment for redirection, not punishment. She even requested a behavioral incentive date after 2 years, hoping that if Mr. Jones stays out of trouble, he can wrap up probation early. It's the kind of ask you don't make unless you believe your client is genuinely ready to move on from this. Judge McBurney, staying true to form, weighed all of this carefully. There was no grandstanding, no speeches, just a steady, respectful handling of a plea with some complexity behind it. You could tell he wanted Mr. Jones to succeed and that the courtroom wasn't interested in hammering someone who still had a clean felony record at 40. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one.